Good afternoon, Chair Khan and Chair Chang-Diaz. My name is Ben Klein. I'm a lawyer with GLAD, GLBTQ, Legal Advocates and Defenders. And I wanted to begin by focusing us all here today on what this bill does and does not do, because it's a very narrowly crafted bill that prohibits one thing, and that is a practice that changes an individual's sexual orientation and gender identity. It does not, or gender identity. It does nothing else and does not otherwise prescribe speech, opinions, or viewpoints. And as a bill that focuses on regulating a practice of health care, that is squarely within the state's well-established and long-standing police powers to regulate the conduct of health care, especially when we're talking about minors who are particularly vulnerable. I would like to take, in the time I have, a few moments to actually focus on a Supreme Court case from June of 2018, which some of our opponents are positing provides grounds to challenge the constitutionality of conversion therapy laws. And to provide you some context there, that case, the National Institute of Family and Life Advocates versus Becerra, sometimes referred to as NIFLA, deals with completely different legislation. It does not deal with a statute that regulates professional conduct like this bill does. That was a case where California passed a law requiring pregnancy crisis centers which oppose abortion to post notices making people aware of publicly available options for family planning. In the context of deciding that case, and the opinion was written by Justice Thomas, the Supreme Court actually affirmed laws just like this one, because what they said was this court has upheld, that's the Supreme Court, this court has upheld regulations of professional commerce or conduct that incidentally burden speech. And the court said that those kinds of restrictions are not prohibited by the First Amendment. And they gave as an example, Justice Thomas gave as an example, malpractice claims. So if we were to accept some of the opponents' assertions that you can't regulate conversion therapy because it's speech of the therapist, there would be no such thing as a malpractice claim against a psychiatrist. There would be no ability of the Board of Registration in Medicine to discipline a provider who is providing substandard care to a patient and harming them, because that would all be speech. But what the Supreme Court has said, and what is the prevailing view among the courts, and all the appellate courts have upheld conversion therapy so far, is that when the speech is incident to conduct such as providing medical care, that is well within the state's regulatory authority, and that is why these laws are constitutional. And the Supreme Court decision of 2018, June of 2018, actually affirms the constitutionality of these bills and does not undermine them. Great. Thank you.
Thank you very much for your testimony. Do we have any questions?
Madam Chair?
Yes.
Okay. Thank you very much, Attorney Klein. And so I read the case because I had heard some of the similar arguments raised, and I just wanted to have you expound on a couple of the points that you made. One, in terms of professional speech versus professional conduct, can you just maybe expound upon that? So it's your view that this legislation before us would purely be considered professional conduct and not just speech, and therefore not implicating NIFLA? Is that
That's correct.
fair to say?
That's correct. So one of the things that was going on in the Supreme Court decision, looking at this notice provision under California law that had to be posted, was what is, the court was asking, what is the concept of professional speech under the First Amendment, and what level of scrutiny should professional speech be given? And that's really a separate question. And what the court then did was go on from there after striking down the California law and saying, no, they found it unconstitutional to compel these clinics to provide these notices. But they said there are certain kinds of speech that we do understand to be simply incidental to conduct. And they specifically referenced, it said the First Amendment does not prevent restrictions directed at commerce or conduct from imposing incidental burdens on speech, and professionals are no exception to this rule. And then they gave as the example torts for professional malpractice, for example, fall within the traditional purview of state regulation of conduct.
To follow up, if I may, Madam Chair. So would you also agree that pure talk therapy, as they call it, for lack of a clinical term, is also, even though we think of it as speech, it's actually professional conduct? Is that fair to say as well?
That's right. It is.
The courts would say.
It is conduct, and that's what the appellate courts. Both appellate courts in our federal system that have ruled on conversion therapy laws have upheld these laws. But I do want to just say, in light of the Supreme Court's decision, that some of our opponents have been emboldened by this decision and have taken, I think, out of context some of its lines to challenge these laws. And so we should not be surprised if that at some point, we have on the federal trial court level, we have almost 900 federal trial court judges in the United States. And there was one recently in Tampa that did say that these laws were really talking about pure speech. Now, I think that decision was wrong. It was poorly reasoned. It ignored the language in the Supreme Court decision that I just read to you. And a few weeks later, another federal trial court said these laws are upheld under every possible level of scrutiny under the First Amendment, and they don't regulate speech. And the point that I just want to leave with you in terms of context of the development of the law is that given the number of trial court judges we have, it's not surprising that you could find one who might take a view that we think is unfounded, but that doesn't change the legal landscape, that the prevailing view in American law is that the state's authority to regulate the conduct of healthcare is well established, and the Supreme Court said that in the NIFLA decision.
Attorney Klein, if I could just may follow up. Thank you, Madam Chair, for your patience. Is it fair to say that the Planned Parenthood Casey decision will also support this idea that, I think that was regarding informed consent, that this whole idea that even though the doctor was regulating speech, it still was professional conduct? Would you agree that supports the whole line of reasoning that this is conduct, not speech?
I would agree with that, and here's what the Supreme Court said about that case. They said that law that you're referring to regulated speech only as part of the practice of medicine, subject to reasonable licensing and regulation by the state, and upheld that provision. So speech is obviously part of almost everything we do. Doesn't mean that that everything is therefore subject to First Amendment scrutiny.
Thank you. Thank you, Madam Chair.
Thank you very much.